show toward what was the first step toward a journey for a just verdict. And when we talked in voir dire, we asked you questions, you filled out a questionnaire, and each of you indicated that you would look at the proof, look at the evidence, and make an honest decision. Now, what I'm going to do is talk to you about reasonable inferences that can be drawn from the proof. All of the proof. So one thing I want to be very clear of as we go through this process toward a just verdict, it really doesn't matter what I say, because I'm here to speak on behalf of 20-something-year-old Kenny Bartley, or what the prosecution says. What matters is your opinion of the evidence. And the state's job is to prove each and every element, every fact regarding my client's intent beyond a reasonable doubt. Now, as we said during voir dire, when we had our dialogue in Hamilton County, Tennessee, the law presumes Kenny Bartley to be innocent. As he sits here, he is cloaked in that presumption of innocence. He is entitled to the same respect and dignity that anyone in this courtroom has. As I also said, under our system of justice and our Constitution that's affixed on the wall over to my left, Kenny Bartley or no one has to prove anything. It's not our job. That's the state's burden. Each and every element, each and every refutable fact beyond a reasonable doubt. Now, Abraham Lincoln said, jury service is the highest act of citizenship. You have the honor or the job of performing that highest act of citizenship we can do. And one thing I want to be clear as we talk about the reasonable inferences, this isn't a decision to be made on sympathy or passion, because Kenny Bartley was 14 years old. I want to be clear. It's not a decision to be made on sympathy and passion because people were unfortunately shot on November 8th. It's a decision that must be a just decision based on the evidence. And I'll be honest with you, I have a fear in getting ready for this case after hearing the proof and whatever. I have a fear that you may be swayed by your passions, by your sympathies, maybe toward the prosecution or maybe toward Kenny. But that's not what the judge is going to instruct you. What he is going to instruct you and what your job is to ensure the state proved 14-year-old Kenny Bartley's intent beyond a reasonable doubt. So in doing so, let's talk about what we heard during this journey that took us to the Campbell County High School on November 8th of 2005. One thing we know for sure. We know Kenny Bartley was 14 years old. Now, they call him the defendant. Mr. Ripley points at him, talks about the conduct of the defendant. His name is Kenneth Bartley. And Kenneth Bartley went to school that day, and he made some decisions that weren't smart decisions, but as we walk through that day and you hear the proof and you listen to the state's theory, because again, what they say and what I say is not the evidence, think about these two terms, reflection and judgment. Then think about a reckless act. Think about intent. And I would submit to you, and as I sat here and I heard the state's proof, the state had a flip chart. They kept flipping over, telling you that we proved this count, we proved that count. You know, it seemed like the chart was written before the proof in the trial. I think the chart was written before the proof in the trial. You know, it's interesting when they talk about, and this is an absolute, to prove my client guilty of a premeditated act, they would have to show beyond a reasonable doubt that this 14-year-old exercised reflection and judgment. He didn't panic. He wasn't scared. Lewis Carroll, who wrote Alice in Wonderland, had a favorite saying. When Alice went down to Wonderland and was talking to the Mad Hatter, she couldn't understand him. And the Mad Hatter said, "I'm speaking Jabberwocky." And Alice said, "What does that mean?" He said, "Simply, words mean what I say they mean." And in this case, what you're hearing is reflection and judgment means what they say it means, but that's not the law, and that's not the proof. Now think about it. These prosecutors are telling you that Mr. Kenny Bartley, 14-year-old Kenny Bartley, when he got up and chose to pick out a pair of cargo pants, which most 14-year-olds would do, that's evidence of reflection and judgment beyond a reasonable doubt for first-degree homicide? I agree with one thing they've said: let's use our common sense. And 14-year-old Kenny Bartley made a mistake. And again, I want to be very clear, what happened that day is very unfortunate. And you heard Kenny Bartley on this stand tell you he was sorry. You heard him explain how it happened. But he went and he got some of his father's girlfriend's pills. He took 2 Valium. He was self-medicating. That's what he told the ER. And he got the gun. He put the gun in his pocket. Little, small, .22 caliber Beretta. Now, let's look at reflection and judgment. This proof is uncontroverted, and the state can't say anything else, but the 14-year-old took the gun to school to trade for pills. Kenny Bartley told that to Daniel Hamlet. Kenny Bartley told that to Preston Young. Kenny Bartley told that to the nurse and the ER doctor. There is not a scintilla of proof in the record or a reasonable inference that could be drawn that he brought that gun to school to harm anyone. Never. Now, so if the state, if you listen to their theory, you would have to find a reflection of judgment by putting the gun in your pocket. At that moment, he intended to take that gun and kill one of those principals and shoot 2 others. Again, that flip chart must have been produced prior to the proof in this trial, because nothing could be farther from the truth. Look at the witnesses that observed 14-year-old Kenny Bartley. His teacher said he was acting calm. He was a good student. Asked Miss Castleberry where she'd been. The student said Kenny was calm. He had a gun to trade for drugs. Now, SRO Phillips, who I would submit is one of the most credible witnesses we've heard in this trial, after Mr. Pierce was told Kenny has a gun. Now let's be very clear on the proof on that. Kenny has a gun. SRO Phillips goes to get Mr. Little Kenny Bartley out of class. This is when the unfortunate situation on November 8th starts to unfold. But let's hit pause, because you've heard the testimony of the witnesses. Remarkably, Mr. Ripley didn't mention the words of Kenny Bartley when he sat here and he testified as to what was happening that day in the mind and the life of a 14-year-old. Kenny told you that he put the cartridge in the gun in his dad's bedroom before he ever left the house. flip chart must have been prepared prior to that testimony, because out of 55 minutes of argument, they never even acknowledged there was a dispute. But Kenny looked at you honestly. He answered questions directly. And think about this. A defendant never has to take the stand. And we talk about that in voir dire. But in this case, we wanted to be open. We wanted to be honest. We wanted to be transparent and let Kenny Bartley tell you what happened on November 8th, because he's never had a chance to tell anybody in the courtroom. Tell you what he was thinking of in his mind on November 8th. And in making that decision, in talking to Kenny, that opens him up to the questions of the prosecutors. Remember Lori Phillips Jones? This young man up here is scared. It's her turn to ask questions about how it happened. And suddenly she rushes and she yells and talks about him lying about having a cold, lying about going to the doctor on the sign-in sheet. Is this a search for the truth? Or is this a search to fill in the flip chart that had to be written before this case began? So, reflection and judgment. Mr. Ripley thinks because he got a pair of cargo pants and not skinny jeans, that was his intent to commit first-degree murder. Kenny Bartley was honest. Why would he say he loaded the gun if it wasn't true? Because sometimes truth is stranger than fiction, and sometimes people try to make fiction make sense. Mark Twain said, facts are stubborn things. You make these prosecutors prove the facts beyond a reasonable doubt. Now, SRO Phillips gets Kenny Bartley, has a conversation, and walks him down the hall to Mr. Pierce. The student said, Mr. Pierce, Kenny Bartley's got a gun. They go and they sit in the office. They're alone. Assistant Principal Pierce, SRO Phillips, Kenny Bartley. And I'm not being critical when I say how this transpired. I'm talking about the facts. Because Mr. Ripley said 20 times Mr. Bartley, a 14-year-old, should have had the judgment to give the gun up. Here's the gun. Let me do this. Let me do that. But in this situation, no one called the police. No one asked for any assistance. We know we have a very young man that has a gun. Contrary to what Mr. Pierce said about a student may have a gun, I wasn't really sure. Preston Young told you, I said, Mr. Pierce, he has a gun. So they go to the office. They sit there, according to SRO Phillips, for 15 to 20 minutes. Kenny Bartley told you when he testified, they sat there 15 to 20 minutes. He never brandished a gun. He never made any movements with a gun. He never intended to hurt anyone. Now, we're in the small office. Mr. Seal comes in with Mr. Bruce. Here's where your job is tough, because I would submit that the only version of events that explained what happened was the testimony of Kenny through the eyes of a 14-year-old as to what transpired. SRO Phillips says she walked out in the hall and told Principal Seal, Kenny's got a gun. And he looked at her and said, I'll handle it. When he testified during the trial, he said nobody ever told him anything. We're unclear. Mr. Ripley talks about 14-year-old Kenny Bartley walking Mr. Bruce back to the corner of a room. Mr. Pierce, in his statement, said he never even saw Mr. Bruce. Special Agent Vincent who spoke with him, acknowledged, he said, "I never saw Mr. Bruce come in the room. I only realized that after Mr. Seal told me." He didn't see Kenny pull the trigger or shoot. He never saw him aim. Mr. Seal didn't say that he saw him back him up and shoot or force him to do anything. Now, this young man is sitting there, and at some point, Principal Seal, after Mr. Pierce says, "Do you have something in your pocket?" he reaches in. Kenny's heart is pounding, the adrenaline is flowing, and he pulls the gun out, and in his words, as he told you up here, he was scared and he panicked. This was not an act of reflection and judgment. This was a reckless act of a child bringing a gun to school to trade for medication. He never pulled the gun out before Mr. Seal reached in his pocket. He never brandished a weapon before Mr. Pierce asked for it. And let's talk about what happened next. Kenny says he stood up, he panicked, and they looked at him and said, "Little Kenny, is that real? Little Kenny, is that a squirt gun?" Kenny's backing up in the tight office. "Little Kenny, do you know how to shoot a gun?" Now, that's what Mr. Seal and Mr. Pierce said in their statements, and it's been a while. And I'm in no way being critical of them when I point out their inconsistencies. That's my job as we review the facts, and you make the decision on what, if anything, Mr. Bartley is guilty of, or the state has proven beyond a reasonable doubt. Is it real? Is it a gun? Is it a squirt gun? They weren't sure about that. Now, here's where you're going to have to decide if the state proved their case beyond a reasonable doubt. Mr. Pierce and Mr. Seal said he pulled a clip out. When Kenny sat here, he said to me, and he said to Lori Phillips Jones, the gun was already loaded. I panicked. But Principal Seal and Assistant Principal Pierce said, "We think he pulled a cartridge out. We think it could have come from the right pocket. We think it could have come from the left pocket. We think it could have come from his shirt pocket. But I really don't know." Hard, irrefutable facts beyond a reasonable doubt to show reflection and judgment. There is a significant inconsistency in the proof as to whether there was a cartridge in the gun, whether he pulled a cartridge out of his right pocket, left pocket, shirt pocket, but the state, in their 55 minutes, never acknowledged the testimony you heard from that young man telling you how it happened. Now, at this point, Kenny's scared, Kenny's panicked. You heard Dick Killia, who taught ballistics at Quantico for the FBI, and he told you how the body reacts. Adrenaline starts pumping, your automatic nervous system takes over, and both he and Agent Scott said that weapon can be fired 6 rounds in 3 seconds. So Kenny's backed up. Out of the corner of his eye, Mr. Pierce makes a sudden movement. He turns his head to look at Pierce. He starts firing. He said, "I didn't aim. I was panicked. I scared. I just shot." There was no reflection and judgment in that random, reckless act from a 14-year-old. It's unfortunate. It's tragic. It could have been easily avoided. And again, I'm not being critical, but when you have a child with a loaded gun in school who's going to be nervous, who's going to be anxious, that took 2 Valium and snorted a Xanax moments before, that's why adults handle situations so children don't act in a way that endangers themselves or others. Again, Kenny should have never brought the gun to school, but Kenny never intended to hurt anyone. Did kill you? Scott said 3 seconds. You heard Kenny said, I panicked, I just kept shooting. And let's talk about that, how long it took. 1,001, 1,002, 1,003, and the gun is empty. Now, in terms of the prosecution and their theory, which again I would submit the flip chart was made before they heard Kenny testify, they're telling you that the shots were with reflection and judgment. Nothing could be further from the truth. Mr. Bruce, unfortunately, was shot in the shoulders. He was reaching out, whether he was reaching at Kenny, reaching whatever, whether he's in close proximity, we don't know. He wasn't backed up in the corner of the room being shot at by long range. One individual shot in the groin, one individual shot somewhere else. The spray was random, it was reckless, and it was inconsistent. Everyone that heard the shots, SRO Phillips, Mr. Thompson, Kenny Bartley, told you the shots were rapid, fast, and consecutive. Consistent with what Dick Culia said would happen when you're in the fight or flight syndrome, when your adrenaline is pumping, your automatic nerve system takes over, and you're 14 years old and you're in your principal's office and you know you got a loaded gun and you're traded for drugs. The proof is when Mr. Pierce asked him for that gun and Mr. Seal reached for it, this young man's nervous system took over. Time contracts, space explodes, his perception couldn't be trusted. He stepped back. When he saw Mr. Pierce spin the chair, he shot. 1,001, 1,002, 1,003. Absolutely no proof of reflection and judgment. And again, when you took this job during voir dire and you said you could make the right choice, the tough choice, when you come to work for a just verdict, don't let them tell you that putting the gun in his cargo pants earlier that morning was proof he intended to kill Mr. Bruce or shoot Mr. Seal or shoot Mr. Pierce. That's not a reasonable inference. That is absurd. It was a reckless act. Now, again, you heard from Kenny's mouth what happened and how he felt. Now, this is the danger in a criminal prosecution, because what the state will do, no matter what Kenny Bartley says, they're going to belittle it and they're going to turn it on its head. They're going to turn the Constitution on its head. They're going to try to downplay the charge you'll get on reckless homicide, on voluntary manslaughter, and they're going to try to say that every single thing he did, if he brushed his teeth, reflection and judgment. If he said, I'm sorry, wasn't sincere, reflection and judgment. But think about that. Here's the young man that went down. Mr. Thompson said, I'm sorry, Mr. Seal. He talked to Officer Munger after he left the office. He told Officer Munger that for 10 seconds, I've ruined my life. If I hadn't taken the Xanax, I wouldn't have done it, Officer Munger. And he was crying. But this adult prosecutor looked at you and in trying to play for your sympathy and get you to do a verdict, return a verdict that's not supported by the proof in this case, said, well, Officer Munger said he was just sniffling a little bit. Now, see the dynamic if you're a citizen charged with a crime? If you're crying crocodile tears, you're crying too much. If you're upset and you're crying a little, you're not crying enough. Mr. Thompson said he was upset and he cried. Officer Munger said he was upset and he cried. And you got to see his demeanor on the stand. And I would submit that 22-year-old Kenny Bartley, talking about what he happened when he was 14, was as honest, direct, and open as he could be. When they asked him questions that were hurtful, he answered the questions. When they asked him if the gun was loaded, he said, yeah. But I would respectfully submit, as you look at this proof through the mind of a 14-year-old, there is not a scintilla of proof regarding reflection and judgment, or that it was a knowing, intentional killing. This was 3 seconds of panic, and it's unfortunate. And then when Ms. Castleberry says our policy is when a student's got a gun, we have 4 people and we surround him, the prosecution's answer to that is poor old Ms. Castleberry. Shooting fish in a barrel. It's Kenny's fault. She'd given up the gun, did this. Nobody wants to have an honest dialogue as to how this happened on November 8th. Why this student, who had been given drugs by his drug-dealing next-door neighbor that was a witness for those people, Bill Crowley, how this train wreck happened. This was an unfortunate, reckless, random act. Now, let's talk about the intent, because that's what this case is about, improving the intent of a 14-year-old based on hard evidence beyond a reasonable doubt. We know what was in Kenny Bartley's state of mind when he went to the ER. And if you'll recall, the ER doctor that was called by the state talked about Kenny being treated at the hospital shortly after the shooting. These questions weren't asked by law enforcement. These questions weren't volunteered by Kenny in an effort to cover what had happened. 14-year-old comes to ER by car, laceration over left hand. Patient, he shot it. He's 22, a .22 Beretta gun. Occurred at high school today, this afternoon. Patient had brought gun to school today, intending of selling school in trade for OxyContin. Has been taking the medication off and on since being discharged from Kingswood, approximately 40 milligrams twice daily, 2 or 3 times a week. Kenny's responsive, Kenny's open, Kenny's honest. States some kids asked to see his gun and he realized he'd been told on, took the gun out of his pocket, felt scared, and shot randomly. Again, look at the hard proof, make the state prove 14-year-old Kenny Bartley's intent beyond a reasonable doubt, but this medical record made contemporaneously at the time gives us a unique insight into what the 14-year-old was thinking during the 3 seconds in the office. And he says he took the gun out of the office, felt scared, and shot randomly. Denies having any plans for homicidal act or being suicidal. Respectfully, that record, which captures the intent and the thoughts of 14-year-old Kenny Bartley, shows that this act was an act of recklessness, an act from a scared 14-year-old based on provocation. It does not show any reflection or judgment, or that the killing was knowing and intentional in the shooting. Again, it is unfortunate it happened. Kenny should have never had to go to school, but the proof before you is he was scared and he panicked, and it is 3 to 10 seconds that have changed his life and other people's lives forever. But your job in this case is to determine whether the state proved his intent beyond a reasonable doubt. And I would respectfully submit, and I would strongly urge, that there is absolutely no proof beyond a reasonable doubt that 14-year-old Kenny Bartley acted with reflection or acted with judgment, with premeditation. He was panicked, he's scared, and he shot randomly. And what's interesting is that record, that statement to that nurse, is consistent with what Kenny told you in this courtroom, what Kenny told me in this courtroom, and told Ms. Jones. Nothing has changed in Kenny Bartley's version of why and what had happened. With all the acrimony and pointing and calling Kenny Bartley the defendant, never calling him by his name, there's been no proof that he ever brought the gun to school or hurt anyone. None. Now, years ago, Clarence Darrow was defending two youths in Chicago, very similar to Kenny's age, for homicide. And he decided to waive a jury and have a bench trial and talk to the judge. And his statement in that case, I think, is very relevant and significant to your job in evaluating the proof in this case. And in urging the court to consider the actions of his 14, 15-year-old clients, Darrow argued, before I would take the freedom of a boy, I would try to call back into my mind the emotions of youth. I would try to remember what the world looked like to me when I was a child. I would try to remember how strong, instinctive, and persuasive the emotions were that moved my life. I would try to remember how weak and inefficient youth was in the presence of surging, controlling feelings of me as a child. One that honestly remembers and asks the questions of what a 14-year-old boy would think and feel, calls back the boy and can understand his actions. As you hear this proof, and for a lot of reasons that aren't relevant today, this case should have been a case where you saw a 14-year-old sit in this chair and tell you what happened. So when you're evaluating the intent of Kenny Bartley, as Clarence Darrow urged the judge, think about the emotions, the mindset, and how you process when you're 14. Think about how Dick Culia says fight or flight syndrome works. Think about how Kenny told you he felt with his heart racing And oh, by the way, one thing that you didn't hear from them, I guess they didn't hear the first part of his testimony. Yeah, the first thing Kenny said when he took the stand for the first time ever about this, I'm sorry. But again, if we say we're sorry, it's not sorry enough. If we cry, we haven't cried enough. If we say, what have I done, what have I done, we should have said, what have I done, what have I done, what have I done? But when you evaluate this proof, it doesn't matter what I say, what these prosecutors say. Look at the evidence that's in this trial. But we are, in our presentation, speaking on behalf of Kenny Bartley, have tried to address all the facts. Ask yourself why the prosecution never talked about Mr. Bartley having the clip in the gun, never talked about the inconsistencies in the witnesses' observations about what happened in the office, never talked about how rapidly the gun was fired. But now comes the point, and we're getting close, in this journey for a just verdict that started in Chattanooga, because I've presented everything I can present on behalf of Kenny Bartley. Even though the law did not require it, I chose to put him a few feet from you in that witness box and let him tell you what happened. But now will come the time, although I've had the privilege, along with Ms. Moore, of safeguarding Kenny Bartley's fundamental constitutional freedoms for the past few years, that torch of his liberty and his freedom is going to pass to each of you. Each of you has an individual verdict. And you are the ones individually that are going to decide what the facts are. And I hope, unlike the prosecution, when you were given those notebooks to take notes during this trial, which you all did very diligently, you didn't have anything written on there before you started. Much like the prosecution flip chart that tried to write a closing argument and then cram the facts around peg into a square hole. And ask yourself, if we're here to search for justice and the truth, and they're going to get to go next, and that's the part of the trial that it's hard. You're sitting there because their burden is so high, very, very high. They get the last word. But I would submit that Ms. Jones should ask you why they didn't openly discuss all of the proof. Ask her, or maybe she will tell you, how choosing a pair of cargo pants versus a skinny jean is proof of reflection and judgment for first-degree murder. Ask her what proof there is to contradict the fact that this record from her witness said, I got scared and I shot randomly. Why can't they just tell you that there's sufficient proof that this kid was scared, instead of saying because he got up and brushed his teeth, that meant he planned to kill somebody? But the challenge I will lay to the state, I will ask her to give us one explanation. Ms. Jones, is there any proof before Kenny Bartley went in that office that he intended to hurt anybody on November 8th? We'll see if she can answer that question. But I don't think she can. Now, again, the judge will charge you about different levels that you could find based on the proof, and he will give you definitions. For example, Judge Blackwood will tell you, in terms of a reckless homicide, that means a person acts recklessly with respect to circumstances surrounding the conduct or the results of the conduct when the person is aware of, but consciously disregards a substantial and unjustifiable risk that circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. A 14-year-old bringing a loaded gun to school to trade for drugs. Not a act of reflection and judgment, not a knowing, intentional act of shooting, but an act that was recklessly and created a substantial and unjustified risk. Now, as I said, Mr. Bartley, even though he took the stand and we presented Mr. Culia and the students, never has to prove anything. But the state must prove each and every element of every count in that indictment. First degree, second degree, voluntary, reckless, whatever one, with hard, irrefutable facts. And that's one thing Mark Twain said 100 years ago, and it resonates today in this courtroom. Facts are stubborn things. No matter what they say, how loud they yell, how much sympathy they try to invoke, they can't change the fact that this is evidence of 14-year-old Kenny Bartley's intent the day this unfortunate shooting happened. But reasonable doubt. As I said during voir dire, we have various standards of proof under our system of justice. To pull someone over, you have to have probable cause.
This is my contour, and it's
money damages or take someone's property. It's by a preponderance of the evidence. It's kind of like moving the scales of justice to 51-49. If you're in juvenile court and we want to take someone's child or remove it from a home because it's in the child's best interest, it must be yet a higher standard, clear and convincing evidence. But in a case where you're trying to reach a just verdict, the standard of proof is the highest we have in our system of justice. They must prove each and every element, that's every word in that jury charge, beyond a reasonable doubt to a moral certainty. Beyond a reasonable doubt to moral certainty. And why is that? That's not only because our founding fathers wanted to protect all of us, because during this trial you've seen how hard it is to prove your innocence or your mental state, because if you cry, you're not crying hard enough. If you say you're sorry, you didn't say, I'm sorry enough. If you say you took a gun to school to trade for drugs, well, you must have took the gun to school to try to kill somebody because you put it in your pocket. But what that presumption does is protect Kenny Bartley from prosecutors that make the flip chart up before the trial starts. And it also protects you. Because as we continue, and you are about to begin your deliberations in this journey toward a just, fair verdict, you get to use that standard that says they have to prove each and every fact, each and every element, beyond a reasonable doubt to a moral certainty, just so when you go back to Chattanooga, to Hamilton County, you're not laying awake a week later saying, you know, I really thought this was a reckless act, an act of provocation. But, you know, I was uncertain. Because of that high standard of proof that our founding fathers, whose words are still hanging in this courtroom right now, you don't have to have that dilemma. Because they must prove all of their facts beyond a reasonable doubt to a moral certainty. But when you go back there, look and review the inconsistencies in the witness statements. Consider the demeanor and the responsiveness of Kenny Bartley, who chose to very openly and honestly talk about what happened, about how he felt sorry. He wishes it would have never happened. It's ruined his life. But I'm not here to engender sympathy for Kenny, because it's ruined a lot of people's lives. But please don't make a decision because you feel sorry for Kenny Bartley. Please don't make a decision because you feel sorry for the victims, because this is a job that's not for the timid or the weak of heart. This is for courageous, jurors that are going to follow what the Constitution says. And that's apply the facts to the law, regardless of what I say or what they say. But I hope you know that during this process, this journey toward a just verdict, I have tried, and Ms. Moore has tried, has to be as open and get everything before you as we can. So you should have everything you need. I've not tried to tell you half the story. Two witnesses said there wasn't a clip in a gun. Kenny said there was. They were inconsistent. But when you listen to these prosecutors, ask yourself why. But one thing I would ask that you do before you deliberate is remember the words of Clarence Darrow when he said, I would try to call back into my mind the emotions of youth. I would try to remember what the world looked like to me when I was a child. I would remember how strong these instinctive, persistent emotions were in my life. I would try to remember how weak and inefficient youth was in the presence of surging, controlling feelings I had as a young man. And once you do that, as Clarence Darrow said, you can understand the boy. I would submit, once you do that, some 50 years later, you can understand 14-year-old Kenny Bartley. Thank you for your time and attention on behalf of Mr. Bartley. After hearing this proof, we are convinced that you're going to find the facts and that the state has not proven beyond a reasonable doubt Kenny Bartley committed a first-degree homicide. He did not commit a second-degree homicide. Accordingly, he did not attempt to do first-degree homicide or second-degree homicide, and he most certainly did not commit felony murder. The only felonies I think this proof, and when I said we're going to be open and transparent, we're going to be open and transparent. He did bring a gun to school. He did bring drugs to school. But those felonies are not sufficient to have a finding for felony murder under Tennessee law. So as part of our open, transparent journey for a just verdict, I'm not going to sit here and tell you that he didn't bring a gun to school beyond a reasonable doubt. And I'm not going to tell you that those pills they showed you weren't brought by Kenny and it's against the law. But I most certainly will tell you that they did not prove first, second, attempted first or second beyond a reasonable doubt. And I'm asking you to return the appropriate verdict for the reckless, random act that happened on November 8th. Thank you for your attention.